Okay, on the record in the matter of the people of the state of Michigan versus Kevin Anderson Mallet, 20-01427. For the record.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people, making motion to practice under Michigan Court Rule number 8.120.
Morning, Your Honor. Attorney John Abbott representing Mr. Anderson Mallet. He's standing to my right.
What was the date that was scheduled? Jury trial, but I think late yesterday we converted this to a final pre-trial. Some issues making contact with some of the witnesses.
Yes, Your Honor. If I may make a record.
Yes.
Your Honor, at this time, the necessary witness to this case, Adriana Ireland, has failed to appear. We have attempted to contact her several times. Admittedly, this is an older case. It's from 2020, so I'm not sure if we have the wrong number or what, but out of an abundance of caution, the Lansing Police Department had a new detective assigned last week to this case, tried to track her down, and was also unavailable to make contact. So at this time, the people are unable to proceed.
Move to dismiss, Your Honor.
Motion to dismiss is granted. It's granted without prejudice, and people would have the right to reissue this matter within the statutory time frame. Okay. Do you have any questions?
Do I still have the services? I believe?
Were you reporting the pre-trial services?
Yeah.
You should not be. That actually should have ended once this matter was converted or moved forward as just a misdemeanor. This must have started, it wasn't felony. You do not need to report to pre-trial services anymore. Your bond conditions will terminate as soon as this is entered into the system, okay? Do you have any questions?
No, I don't.
We'll get you a copy of that in just a moment. Any additional matters for the record?
Nothing from the people.
Thank you, Your Honor.
On the record in the matters of the people of the state of Michigan versus Ernest Eugene Bush, 23-03168, 21-00738, 23-03168 again, and 24-00409. Council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Rally on behalf of Mr. Bush, Your Honor.
Okay, today was the date that was set for final pre-trials and one bond violation. How are we proceeding?
Your Honor, regarding the bond violation, the people would be requesting an adjournment of that. Your Honor would want to adjourn all of the final pre-trials. I have no issue with that either. However, I'm not formally requesting that. With the bond violation specifically, it is the exact same police report and the exact same facts, as well as the exact same witnesses for the preliminary exam that's already scheduled this Friday for Mr. Bush. So I would be requesting to adjourn the PA-53 since it would be all the same testimony and witnesses Friday. Regarding the final pre-trials, I have attempted to contact the necessary witnesses on these cases, Samantha Barrett and Lori James. I attempted to contact again yesterday. I have not to this point been able to successfully contact them, and I have not seen them in the hallway today, so the people are unable to proceed on the final
I see one for. Samantha and Jean are the same person, correct?
Yes, Your Honor.
Counsel.
Oh, Your Honor, I would certainly motion to dismiss all the pre-trials, final pre-trials that is, as well as the violation. And my understanding is that the violation requires a second witnesses at least one or two of these final pre-trials. So I don't see how that can proceed if they can.
Oh, so the bond violation is connected or has the same set of facts as the exam that's scheduled for this week?
Yes, Your Honor. The exam that's scheduled for Friday, Mr. Pfeiffer, Adam Pfeiffer, is handling that. I believe he is planning to proceed victimless even if Samantha Barrett does not show up on those files, but it is my understanding that he has had contact with Samantha Barrett. I just have not, and I do not see her today. an eyewitness on one of these cases did show up this morning and advised me that Samantha, at least as far as she knows, does plan to show up Friday. So I know that's not much, but
I already set the bond violation and that entire file actually to Friday's date time. First at 8:30. As to file number 24-00409 and 21-00738, the motion dismiss is granted. Without prejudice. Any additional matters for the record?
nothing from the people.
No, Your Honor.
Okay, Mr. Bush, the people do have the right to reissue those charges that are being dismissed without prejudice within the statutory time frame. Okay?
Yes, ma'am.
Okay, we'll see you on Friday.
Thank you.
On the record in the matter of the people of the state of Michigan versus Shawan Calvin, 24-02534.
Ms. Donnelly's got the phone, just in case, so I'll-
Could be just me.
I can appear consistent.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
I'm Jacob Rowley on behalf of Shawan Calvin.
Okay, and Shawan Calvin is present from the Ingham County Jail Polycom. Today's date scheduled for final pre-trial on assault and battery. How we proceed?
Your Honor,
It's amended. It was an attempted RNL. How we proceed?
yes, Your Honor, it was an attempted RNO and then entry without owner's permission regarding the underlying files here. The necessary witnesses have informed me that they do not want to proceed to a trial on this matter. They would prefer that things get dismissed today. I also have not seen Sierra Johnson, the necessary witness for the entry without permission. So the people are unable to proceed at this time.
Defense motion to dismiss, Your Honor.
Motion to dismiss is granted without prejudice. The people can reissue this charge against you in the statutory time frame if the necessary witnesses change their mind. Okay, sir?
Yes, ma'am.
You have any questions?
No.
Any additional matters for the record, counsel?
Nothing further from the people.
No, Your Honor.
Sir, that file. You're all set, sir. On the record in the matter of the people of the state of Michigan versus China Roberts, 23-03624. Appearance, please.
Your Honor, case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Ms. Roberts, who is standing to my right.
Okay, Ms. Roberts, today was the date scheduled for jury trial. We have the witnesses here.
Your Honor, I don't know if the necessary witnesses are here or not. I informed them that this was going to be a plea, so.
Your Honor, we were previously set for a trial and witnesses had appeared, which is part of why we're resolving this week today.
But yes, Your Honor, they have appeared at previous hearings, including trial day.
I'm reviewing the notes. We attempted this very same plea before. Disorderly jostling. And the plea failed because the defendant stated she didn't hit her. She just pointed her fingers and didn't reach into the vehicle. So I don't know if that the factual basis is going to change this time, but we can try.
And thank you. And I do have an advice of rights at this time. I did review what the, I suppose, elements of disorderly person jostling are with Ms. Roberts. I believe she was a little confused and overwhelmed by some of the questions that were asked of her last time. So we've reviewed the situation that occurred as well as the elements of a disorderly person jostling charge. And I do think we'll be able to successfully interpret today.
And that's what you want to do today, Ms. Roberts. You want to enter a plea to the amended charge of disorderly jostling. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, put your hand down. Again, you have the right to proceed to trial because you have the right to the presumption of innocence. You're innocent until proven guilty. And you have the right to require that the prosecution prove your guilt by proceeding with your trial, jury or non-jury, and having them prove each element beyond a reasonable doubt. You understand that?
Yes.
You have the right to remain silent at any trial and not have the silence be used against you. You can waive silence and testify at your trial if you'd like. You can also subpoena witnesses that will testify on your behalf. These are all rights that you would give up, including the right to cross-examine or question any of the witnesses that the prosecution intended to call against you. You understand that? And you want to give up all of those rights?
Yeah.
Anybody threatening you to get you to do that?
No.
Has there been any promises made to you to get you to want to give up these rights?
No.
You're not currently on probation or parole, correct?
Correct.
You understand that a guilty plea could result in a conviction that you may need to report to your current or future employer. It also could have impact on where you can travel or seek immigration status. As to the amended charge of disorderly jostling, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes.
Factual basis, Captain.
Thank you. Ms. Roberts, is it true that on or about September 27th of 2023, you were present at or near South Cedar and Mason Street? Is that in the city of Lansing, Ingham County, Michigan? And at that time, did you jostle or roughly crowd an individual named Nesia Nickens?
Yes.
That was in a public place and that was against her will?
Yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the prosecution?
No, Your Honor, the people are satisfied with the factual basis.
The court is also satisfied with the factual basis. I'll accept your plea and I find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing December 5th at 9 a.m. When you leave here, you go down one floor to our probation department to check in. They will get you prepared for a pre-sentence interview. They'll advise me as to how they believe you should be sentenced as well as your eligibility for any sentencing under HYTA, okay? Do you have any questions?
I was just gonna ask if I can pay my fine.
It's fine. I haven't assessed any fines yet, so, but you're on the right track because technically fines are due the day of sentencing. People show up here and they've not been advised that by their counsel that they need to be prepared to pay that day. But you have not been assessed any fines at this time. But you should be prepared to the extent that you may get fined on the date and time of your sentencing, which is December 5th, okay?
Okay.
Don't forget to go check in downstairs with our probation department. Will get you down in just a moment, okay? Any additional matters for the record?
Nothing from the people. Thank you.
Nothing further.
And you can appear via Zoom for your signature.
Thank you.
Jordan Brown is in custody, consults Foster and Heather. Heather's probably downstairs, so correct? From Eaton County.
Yes, she's downstairs.
From John. Let's see. On the record in the matter of the people of the state of Michigan versus Lakari Bryant, 24-02487. Hearing for the record.
Morning, Your Honor. Case marked hearing and appearing on behalf of the people.
Jacob Riley on behalf of Mr. Bryant.
So, Mr. Bryant. Today was the date that was scheduled for a pretrial. This is for operating while intoxicated. I have here an offer.
OWI second offense.
To amend the charge to an OWI first offense. Pillar Grove North Front Jail. That's completed and accurate.
I have a signed advice of rights.
And so, Mr. Bryant, you want to accept the offer?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth without penalty of perjury? Okay, you can put your hand down. I have an advice of rights and a plea information sheet. It's dated for today. There is a signature or at least some initials on the bottom. Is that your signature? Did you read this document? You understand the rights here? And you want to give up all of these rights in order to plead guilty to the amended charge of operating while intoxicated first offense?
Yes.
Okay, so you understand your right to the presumption of innocence. That means you're innocent until proven guilty, and you have the right to require the prosecution prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You also have the right to remain silent at any trial, not have silence be used against you. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you. You can subpoena witnesses to testify for you at trial, present evidence at trial that you believe show defense to the charge being brought against you. Waive your any right to silence and testify at trial if you like. You understand that? Those are all rights you want to give up? Anybody threatening you to get you to do that? Has any promises being made to you to get you to give up the rights and plead guilty to the amended charge? Are you currently on probation or on parole? You understand that by entering a guilty plea to the amended charge, it could have impact on where you can travel or get immigration status. You also would likely need to report this conviction to your employer or put this conviction on future job applications. As to the amended charge of operating while intoxicated first offense, please. Factual basis.
Right. Mr. Bryant, on February 4th of 2024, were you operating a motor vehicle on South Cedar Street near Miller Road? Is this in the city of Lansing, Dane County, State of Michigan? This is a road that was open to the public. Had you consumed some alcohol before driving? Did you have contact with police at some point? Stopped by police? Did they tell you why they stopped? Do you have any reason to believe that your stop was invalid or illegal?
I can't hear.
I don't remember.
You don't remember the stop?
Like the way I was driving. Like he said, like I didn't turn all the way in lane or something.
And then you don't remember the way you were driving, or you don't remember the interaction with the
I
police?
don't remember. No, I remember like where I was going and stuff, but I'm talking about like if I was really like outside of the lane. But
So what your concern is, or your hesitation is about whether or not there was a valid stop. Is that your concern? Okay, counsel.
Not valid before, but they did not.
Okay,
so,
he doesn't believe he was validly pulled over. I'm not accepting the plea. We'll give you time to discuss that further with your attorney. And maybe he may want to file a motion. That's up to him. We'll reset this. And that gives you more time to discuss that with Mr. Rowley, okay, about the validity of the stop, okay? You get a new date. November 12th at 10:30. November 12th at 10:30.
Is that going to be a reset pretrial, Your Honor, or?
Correct. Your attorney, I don't know if he has body or the dash cam, but if that request needs to be made and that's not enough time, just let us know. We can push it out.
Believe discovery.
Yeah, I don't know if that
It's an
includes
MSP
video.
file, so it's a
Oh,
little more difficult to show
got
the
it.
discovery. Make sure that's done for the next year.
Sounds good. Any additional matters for today's record?
From the people.
No, Your Honor.
Okay, we'll get you a notice to appear in just a moment, sir. On the record in the matter of the people of the state of Michigan versus Trayvonte Kirkland 240123661. No Trayvonte Kirkland present.
You know, that's one of our. Might be a city.
State of Michigan.
Maybe it's an attorney general case then, and that's what. I'm not sure. I didn't have any
This
record.
way out. Why do they tag this as the state of Michigan? I have no idea. Oh, LCC did this, so they probably did it. Either way, Mr. Kirkland did not appear. Should be sure. On the record in the matter of the people of the state of Michigan versus Jennifer McCarty, 24-02640. Council appearance.
Morning, Your Honor. Case marked hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. McCarty. I do not believe she's present, Your Honor, and I've been unable to contact.
I believe a bench warrant was issued on Friday, Your Honor, which you failed to appear at probable cause conferences and the bond was forfeited already. So I'm not sure if you need to do it on this file.
Yes, because she's not in warrant status on this file. I should make one of these. Okay, on the record, in the matter of the people of the state of Michigan versus Cadence Lundell, 24-02054. Council appearance.
Good morning, Your Honor. Case marked hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Ms. Blundell, who is standing to my right.
Okay, John, Heather, he needs his next court date. We should print it out. Okay, today is the date and the time that was scheduled for a sentencing. And I am in possession of a pre-sentence report and recommendation, which somehow was prepared today. At least that's what the date on it says. Did you get a copy of that?
I do have a copy of it, Your Honor. Your court officer provided it to me yesterday, so I think there might just be a typo in the month here.
Any need or reason to make corrections, updates, or deletion?
Your Honor, Ms. Blundell brought to me one update she'd like to make the court aware of, as she's trying to be very much upfront and honest here with the court. She did not remember it while doing this interview, but she did feel it was important to advise the court. She does have a prior MIP from a little while back. While not criminal, she wants to be upfront with the court about that.
I'll look at it here. Thank you for providing that update. Any other changes?
Not really, so, Your Honor.
to make allocution.
Thank you, Your Honor. While Ms. Blundell is someone I'm fairly new to, I've had several conversations with her. I've also been able to speak with her prior attorney regarding her conduct throughout this entire case. And she's clear both to myself as well as private or previous counsel as someone who is incredibly forthright in the mistakes she's made and her attempts to move on and improve herself from them. I think that's reflected here in the PSI of when she's admitting that she has struggled and stumbled and how she does desire to make a better life for herself moving forward from this. That's including already attending things like 12-step meetings. This is her forthrightness both to the probation officer during this report and even today with the court for her desire to make sure that she is being honest and upfront with the court so she can put herself in the best possible path forward. To that end, I do think the recommendation is a fair one here from Ms. Bayless, that being the term of probation. She is working right now. She does have a good support system. Family members continue to attend court hearings with her, including today, her mother appeared as support for her. And I think this is a young woman who can take full advantage of probation, not just to get through it, but to take advantage of it. So I do believe that the opportunities, as I'm going to call them here, provided within the report are good for her, including the outpatient treatment and the continuing 12-step attendance. To that end, Your Honor, I would only point out that Ms. Blundell is indigent. She is working. She is getting an income, but some of these things can get quite expensive, including the outpatient on top of testing, on top of everything else required here. And I would only ask the court to keep that in mind when assessing any discretionary fines and costs here for Ms. Blundell. Thank you.
Did your client want to make a statement about?
Quite nervous, Your Honor. I don't think she wishes to make a statement.
Yeah,
It's normal to be nervous.
okay.
It's normal. If you want to say something, you can. That's up to you. You don't have
I'm
to.
not really sure what to say.
You don't need to say anything. You have an attorney, so you can always maintain your silence unless, of course, there's a question that's posed that we need your response for.
Yes,
Like, for example, this record tells me that you only completed the 11th grade. Is that accurate?
yes, I struggled with school, yeah.
You said you struggled with school.
Yes.
What does that mean?
I kind of had a rough childhood, not that that's an excuse at all, but I sometimes was like living in the car with my mom just because of certain situations when my dad, and I feel like I didn't get the knowledge that I needed to at a younger grade to be able to accomplish.
The foundation was a little rocky.
Yeah,
The-
I've
the-
definitely tried. I
And
apologize.
you made it to the 11th grade, so this doesn't seem like a struggle. Seems like you were almost done. That's why I asked, because I'm gonna order you completed.
Yes, Your Honor.
And you can do a GED program or a high school diploma program, but you're so close. And realistically, at your age, you're very young. I mean, even as you stand here, you look like you're probably about 12. But if you ever want to do better, your attorney mentioned you're indigent. You don't want to live a life of indigency, and it's not necessary because you're so young, you have your whole life ahead of you, and you've made some mistakes, but there's still so much time for you to correct them and get on track. And at first, it's going to start with an education. And so you need to get some treatment and education as it relates to the underlying issue, but then you also need to finish your education so that you can have better opportunities. You understand that?
Yes, Your Honor.
And so that way, the story that you just shared about having the challenges that you had from the beginning doesn't become your destiny. That's just will be a testimony about how you became the person that you will become in the future. I don't know what your goals are, but I'm sure you have some. And so we want to encourage you to try to pursue those, but it's going to start with some education, and I'm going to hold your feet to the fire during this time, because I'm going to adopt the recommendation, which is for a term of probation. I think it's appropriate under the circumstances. I'm happy to hear that you've already been attending 12-step support groups for the last couple of months and other meetings, even having the support of your mom and doing those things, and that the dates that you reported for the use of substances, both alcohol and marijuana, are behind you. So that's the positive in your favor. The recommendation is for 9 months of probation. I am going to adopt that. There will be 9 months probation. You'll be ordered to continue to attend the 12-step meeting with providing verification to your probation officer. Right now, you're doing that 1 time per week, or is that correct? We'll continue it at 1 time per week. But also order that you complete the victim impact panel. I'll give you 90 days to do that. You need to provide verification that you've completed the victim impact panel, okay? So, you're gonna be required to enroll in a GED or high school diploma program. You need to be enrolled within the next 30 days, okay?
Yes, sir.
And you'll provide evidence of that enrollment. You're going to maintain your employment and provide evidence of that, okay?
Yes, sir.
While on probation, you're not to use, purchase, or possess alcohol, marijuana, or a controlled substance unless you have a valid prescription. You're going to be required to submit to random preliminary breath testing and urinalysis testing, and you are responsible for the cost of that, okay?
Yes, sir.
You're not to be at any bars or nightclubs, okay?
Yes, sir.
You're not to engage in any assaultive or threatening behavior, and you're not to use, purchase, or possess a firearm, weapon, or ammunition of any kind. Do you have any questions so far?
No, Your Honor.
I'm gonna also order that you perform 10 hours of community service. I'll give you 45 days to do that, okay? Well, I'll give you 60 days. It's the holidays. There'll be so many opportunities for you to complete it before the end of the year. So I'll give you to the 31st of December. Fines and costs is a $75 crime victim rights fee plus a $50 state minimum cost and a $100 assessment fee. There's a $120 cost recovery owed to the prosecutor's office. So we don't typically go over that process. Probation oversight fees, $30 per month. You're gonna do 9 months, that's $270 that will be assessed. I'll waive discretionary fines and costs.
Thank you.
All right. It's a total of $615. You'll be able to make monthly payment on that, okay? Lastly, there's an advice of rights act to probation. It states that you've been placed on a term of probation before the 54A district court, and your terms are individually tailored and are specific to address your assessed risks and needs. And you would be eligible to make a request for early discharge, but you would have to do that after first completing half the original term ordered by the court. So about 4.5 months in, you would be able to make the request. In your particular case, in order for you to make a request that I would consider as reasonable. You would have not had any violations within 90 days preceding your request, and you will be successfully enrolled and participating successfully in your GED and or high school diploma. You're still working. You're still doing your 12-step programs as ordered, and you've not had any issues with testing. And then you can make the request. You would make the request using the court's MC 512 form. That form is on the court website, or you can just ask your probation officer to email it to you or pick up a copy from your probation officer. The probation officer does have the ability and the right to request it on your behalf without you making the request. If I set it for a hearing, to address the request, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court-appointed counsel to represent you for any hearing for early discharge. However, I've never held a hearing for early discharge. That shouldn't be an issue. Do you have any questions about those rights? Okay. If you could just initial indicating that you've been advised of those rights.
May I put your honor?
Yes, thank you. Okay, when you leave here, you'll go down one floor to the probation department, check in to make sure they have all accurate information for you. They will put together a judgment of sentence based on what we just discussed here today. You'll have to review it and sign it, and then you'll be reporting via Zoom for your probation, okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
The additional matters for the record.
Further, your honor.
Good luck to you. If all goes well, I likely won't see you again. If I see you again, that means something's not going well. Okay?
Yep, I understand, Your Honor.
Thank you.
Your honor, Mr. Markarian just brought up a very good question to me, and I apologize, I must have missed it. The original plea involved a HIDA status.
I don't know if they addressed that on there. Can you pass it?
I didn't see it on the
I'm-
PSI. You're right.
I
I
didn't
didn't see your
either.
honors, why it didn't occur to me. Thank you, Mr. Markarian.
They didn't address it. I have a criminal history. There was nothing else other than this. Not even a driving. record. She doesn't have a license. Is that accurate? You don't have a driver's license?
I got my driver's license, but they took it away.
Oh, okay,
And
it
it's
just does not
suspended as a result
license.
of
Got it.
this.
Okay. There was zero information for her driving record. I don't know why they didn't address HYT status. Other than it wasn't checked on my report. That's why. Who's that? Oh, it wasn't checked on the referral. That's probably why they didn't do that. She's eligible. HYTA status is granted.
Thank you very much, your honor.
You're welcome. Any additional matters for the record?
Nothing from the people.
Nothing further.
Crossings on Polygon, Eaton County.
Yes. Whatever they post one as soon as she's done with it.
Okay, sounds good. What about Brown?
He's downstairs.
Oh,
Jordan Brown.
yes,
Should be a plea, Your Honor. So we'll probably need it brought up.
Jordan Brown.
Yes, Your Honor.
Okay, and then we have Heather up here
Yes.
on the record in the matter of the people of the state of Michigan versus John Heather, 24-02693. Appearance, please.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Jacob Riley on behalf of Mr. Heather.
Okay, Mr. Heather, the date that is scheduled is for a pre-trial. This is a retail fraud, third degree. How are we proceeding on this?
All right, this one, I'm going to be requesting an adjournment. Mr. Heather tells me he plans to retain private counsel. He's going to be in custody in Eaton County until December 15th. That's right, Mr. Heather?
Yes, go ahead.
That's his outtake serving sentence. So his request would be that this matter be adjourned until after December 15th.
I'm not joining to actually. I'm gonna join into the next available report date. November 12th at 10:30. Have any questions today?
No.
Okay. Any additional matters for the record?
Your Honor, if I may,
Yes.
there was an offer extended on this case. I just want to place on the record. It was to plead guilty to attempted retail fraud, third with restitution in the amount of $119.98.
$119.98. Okay. And that offer was communicated to you previously, sir?
I might have misspoken when I spoke to him earlier. I thought the offer was retail fraud third, which is already charged with, so my apologies, I didn't think that.
Do you want some time to talk about it? The record. Did you have somebody?
Yes, Your Honor. Mr. Williams is here.
Ronnie Williams?
Yes, sir.
Okay, on the record in the matter. Of the people of the state of Michigan versus Ronnie Williams. Four dash 02303, council appearance.
Good morning, Your Honor. Case mark hearing appearing on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Williams, who is present and standing to my right.
It's probably in the word. Where do you want? Who should we start with? Okay, go ahead. Oh, she's my nomination. Yeah. Oh. I don't have the file up. Okay, I have the file now.
Okay. Didn't know if you called me.
Okay, on the record in the matter of the people of the state of Michigan versus Ronnie Williams, this is 24-02-303, council opinions.
Good morning, Your Honor. Mark Darian, appearing on behalf of the people.
Morning, Your Honor, Assistant Public Defender Aaron Schroeder on behalf of Mr. Williams, who's present staying to my right.
Okay, Mr. Williams, today was the date that was scheduled for sentencing. I don't have a sentencing file for you. Do you know why? I don't, your head nods.
No.
Okay. Did you report to probation as ordered? Why?
Just slipped my mind.
It slipped your mind?
I was under the understanding that after sentencing, that's when I go down to the PSI.
No, I told you because I wrote it out. You need to appear in probation by Thursday, 10 a.m. No, that was on September 3rd, right, when I told you that you needed to appear to our probation department in person by Thursday at 10 o'clock in the morning. So whatever day that was, I'm assuming I saw you on the 3rd, I'm assuming that was on a Tuesday. I told you you needed to be there by Thursday at 10 o'clock in the morning, since I must have saw you at about 10 o'clock in the morning that Tuesday. So, and then I asked you, did you have any questions, which would have given you an opportunity to clarify any confusions or lack of information or understanding. And so because of that, I'm not able to sentence you. There's actually a warrant. You're remanding you to Ingham County or to the custody Ingham County Jail so that we can get you into compliance with my order, okay?
You're getting a ring.
Yeah, I was quite into that too.
I will try to see if I can get it.
And so you will have, I'll let the probation department know that you're in custody so they can move forward with the pre-sentence interview as you were supposed to. I'm gonna have to reset your sentencing. December 6th at 9. December 6th at 9 is your new sentencing date. Do you have any questions today?
Your Honor, is he going to be held in until he's completed the,
Yeah, it's just remanded to do the PSI.
and then he will be released after that?
They'll notify me once it's done, yes.
All right, thank you, Your Honor.
Thank you. So,
What date was that again?
December 6th.
December 6th, thank you.
Your Honor, are we gonna keep this other one too?
You're entitled for what matter?
For the bureaus that are on the bond, circuit court, they want mine, so.
While you're in custody, and I don't know how long it'll take for them to take care of this. They will probably remove the tether. And then you'll have to get it again when you are released.
What time is that again, Your Honor? I apologize.
9 a.m.
It's going to be subtle.
I'll make it my request.
Okay, Wendy Foster is here, and then the jail post 2 just joined. I'm not sure who that is. It's dark.
You had John.
Oh, okay, I can see him back there. Okay, back on the record in the matter of the state of Michigan versus John Heather. Mr. Heather has now been advised of his offer, which is to plead guilty to an attempted retail fraud third and to pay a restitution of $119.98. You know, you indicated that you wanted to hire counsel. How do you want to proceed now?
He's not interested in that offer, Your Honor. He still intends to retain fresh counsel.
Okay, so we'll continue to the November 12th date, and then hopefully you'll have counsel by then, okay?
I'll attempt to, yes, Your Honor.
Okay. Any additional matters for the record today?
Nothing from the people.
No, Your Honor.
You're all set. Who represents Ms. Foster?
I do now.
Do you need to speak to her
No, I think we're ready. And it's going to be a plea.
on the record in the matter of the people of the state of Michigan versus Wendy Marie Foster, 24-02998. Appearance, please.
Morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Jacob Riley on behalf of Ms. Foster.
Just need one moment to fill out the case sheet, Your Honor.
You want to appear for the show causes? Why you asking fines and costs?
Okay, cool.
Who's supposed to be in post two? Two post twos though. What's that all about? I'm
I
sorry.
can hear you.
Visit rooms, I don't know if there's just multiple people in the same post.
Yeah, who's supposed to be in most of them? Really, we're waiting for Jordan. No, Jordan Brown's downstairs. I don't. Day Wells is supposed to be in custody. Okay, so we have retail frauds, is it second degree, there's gonna be a plea?
Yes, Your Honor. I just need to get Mr. Martinez to sign that.
Oh, okay, well, he can sign it when he gets.
Sounds good.
Okay, and so Ms. Foster is present via Zoom, I'm sorry, Polycom from Ingham County Jail. The offer was to plead guilty to an amended offer of retail fraud, third degree. That's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. Is that the offer that you discussed, Ms. Foster?
Yes, that is the offer that I discussed with Mr. Riley.
And you want to accept it?
I can accept it. I'm working with Judge Allen on mental court for this one that I'm on over here at Ingham County Jail. I just want to let you know, yeah, I can accept
Okay.
it.
Okay, so you have another matter and then you're doing specialty court for?
Yes, I'm good. That's what me and that's what me and Judge Allen Judge Allen and I are working on that together, yes.
Okay, and so you do want to plead to the amended retail fraud third in this court?
Yes, yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. In order for you to accept the offer and enter a guilty plea, I need to understand that you know your rights and that you are willing to give those rights up. First, you have the right to the presumption of innocence. That means you're innocent until proven guilty. And you have the right.
Yes, Your Honor, I'm aware of that.
I'm sorry?
No, go ahead, I'm sorry, I didn't mean to cut you off, it just, yeah, no.
Okay, you have the right to require that the prosecution prove your guilt at a trial. They would have to prove each element of the charge being brought against you beyond a reasonable doubt. Do you understand that?
Yes, I do.
You have the right to see, hear, or question any other witnesses that they intended to call again to testify against you. You can subpoena evidence or testimony by witnesses to your own trial, or you can waive your right to silence and testify at trial if you'd like. You understand that?
I do.
You are willing to give up these rights to enter a plea today to the amended charge of the retail fraud third degree. Is that correct?
Yes, Your Honor.
Anybody threatening you to get you to do that?
No, they did not.
Any promises being made in exchange for you entering a guilty plea?
Yes, I do.
Are you currently are you already on probation?
No. No, I'm
Okay,
not.
what was the promises being made?
I guess I don't understand your question. I'm sorry.
Any promises being made to get you to plead guilty to this charge?
Oh, there is no promise. No, there's no promise. No.
You are on probation already with Judge Allen?
No, I'm not on probation. I have not been sentenced.
Okay, but you're under bond until sentencing on that matter, so this won't likely have an effect on any probation status. You're not on parole, that's correct?
That's correct.
You understand that a guilty plea could result in a conviction that you may need to report to your future or current employer?
Yes, Your Honor.
It also could have impact on where you can travel or get immigration status.
Yes, I'm aware.
As to the amended charge of retail fraud third degree, how do you plead?
Guilty.
Factual basis, counsel.
Your Honor, Ms. Foster, on October 3rd of this year, were you at location of 428 Frandor Avenue, Lansing? Ms. Foster?
Yes, I'm sorry. Yes, I was just listening. Yes. Yes,
And that's an Ulta store, correct?
that's correct.
While you were at that store, did you have contact with police?
Yes,
Did they inform you that you had been accused of, I guess, stealing some items from a different store?
yes,
And is it true that they, in fact, you did have those items on your person and they were discovered by police when they searched?
yes, I did.
Do you, is it true that you had taken those items from that store without paying and that you did that intentionally?
Yes,
That those were items that had been offered for sale to the public?
yes.
Thank you.
Any questions from the prosecution?
Yes, Your Honor, just one. Ms. Foster, do you agree that the value of those items was less than $200?
Yes, I believe the officer said they were below $12.
People are satisfied with the factual basis.
I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently.
Yes,
So there's no restitution on this.
Correct, Your Honor, the items were recovered.
What else is she being held on other than this?
She's being held on that case out of the 55th District.
Any objection to immediate sentencing?
Not from defense.
No, Your Honor, not from the people.
You can make allocution.
Your Honor, as Ms. Foster had stated, she entered a plea on a retail fraud case in 55th District. I believe she's set for sentencing in on November 4th, next week. Your expectation is that she will be going into a mental health court, court situation. I think certainly that's something that she can answer that. So with regard to this case, my request would be sentenced to time served so that she can proceed with supervision and specialty court assistance in that case.
30 days Eagan County Jail credit time served. You're all set.
thank you, Your Honor.
You're welcome.
You have the rest of your day on.
Who's down? Are we ready to bring Holly up?
So
We can bring Holly up.
actually, when it comes to Holly, I think I'm going to request adjournment. So, yeah.
Do you want to bring up Brown?
Yes, Your Honor, on Holly, he's got some felony matters that the facts and the witnesses overlap for. They've been reset to December 5th. Mr. Pfeiffer's handling those at the vertical.
Jordan Brown.
So you want to waive Holly's appearance for that purpose?
Request adjournment, yes.
Okay, and then Brown, do we want to bring up Brown?
Yes.
We'll bring up Brown.
We approach on Parlex Singh, Your Honor.
On who?
Parlex Singh, it's a
Oh, okay.
10:30.
Can you just,
That's what I was about to. Well, you read my mind. I know what you're thinking.
Mr. Mendenhall? On the record, in the matter of the city of Lansing versus Chauncey Mendenhall, this is 24L2896368. And then Mr. Mendenhall, this is a matter that's in warrant status for failure to appear for arraignment on the driving and registered vehicle that you were supposed to be arraigned on back on the 30th of September. What happened? You missed your court date?
Yeah, I don't remember. I really didn't know I had to come.
Okay, got it. Okay.
I thought I just had to come.
That's just for a pre-trial. You didn't realize you'd be arraigned on this. Let's see here. So this is a driving while license, post a citation. And there was also a speeding attached to it, 16 miles or over the speed limit that defaulted. So there's a fine already on that one because of the failure to appear. Looking for the actual, okay. The allegations are that on or about September 2nd, 2024 at 6:14 p.m. in the area of Edgewood at or near American, City of Lansing, Union County, State of Michigan, that you did allegedly receive a citation for driving with registration or plate unregistered. There was also a citation for no insurance, which is a non-waivable offense, and then cited for speeding, charged with driving 68 and a 35. And so as to the driving unregistered, you have the right to be represented by counsel because that is a misdemeanor. If you can't afford to hire an attorney, you can make a request and have the public defender's office appointed to represent you at the expense of the public. You have the right to the presumption of innocence. You're innocent until proven guilty, and you can require the city to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. And you have the right to see, hear, or question any other witnesses that they intend to file against you, or you can testify for yourself by waiving your right to silence, and you also can subpoena witnesses that will testify on your behalf. Do you understand that? Did you want to request an attorney? You don't want an attorney to represent you, you want to represent yourself? Yes, I have to be able to hear your response. Okay, and so that would include the no insurance, the speeding, because I'd give you an opportunity to request to have those defaults set aside, because right now you'd already owe money on these for defaulting. But you don't want to proceed to a pretrial. You want to, how do you want to take care of these, sir? I'm sorry?
I want to I really want to pay them, but I don't want to pay all of them.
And you don't want it, you want me to call the city attorney up here and you negotiate that with them, or you want an attorney to do that for you?
I keep getting all these tickets because the police.
I have nothing, I don't want to hear anything about that. I don't know anything about you getting all these tickets and you blame it on the police. But I want to know how you want to how you want to move forward in this, because I can understand and appreciate that you want to accept some responsibility and pay this, but you want to negotiate something. You have two options. You can request court-appointed counsel. They can make that negotiation for you, or
Hey, can I do that?
or you can, or I can see if someone from the city can come upstairs and then you go outside and negotiate it yourself.
I'll take the court.
You want to request court-appointed counsel? Okay, we have three in the courtroom right now. Someone's going to do an intake with you to get some information, make sure you're eligible to be represented, and then I will set this for a new date for you to appear. I'm going to set aside the defaults on both of these civil infractions. And we'll set it for a pretrial and explanation hearing on the city ordinance day. Enter plea of not guilty on your behalf. Bond on the misdemeanor will be set at 100 personal recognizance. What's your address, sir?
4245 West Valley Road, lot 255,
And your phone number?
517-303-5877.
5877. Okay, we'll get you a notice to appear for those dates. What date are we gonna set this to? It's November 18th. November 18th. At what time? 8:30. At 8:30 will be your next court date, and then you'll meet with, I believe, Ms. Sutter.
Mayor, I apologize. Can you repeat the date one more time?
November 18th at 8:30. No problem. You have any questions today, Mr. Mendenhall? On the record in the matter of the people of the state of Michigan versus Franklin Miller, 24-02450.
Good morning, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Okay, and Mr. Miller is present in court without counsel. Let me just file. Okay, and this is a driving while license is suspended. I think we adjourned this because he was setting up an appointment with Secretary of State. How are we proceeding?
Your Honor, I spoke with Mr. Miller. It's my understanding that he is in the process of taking care of the various things necessary to get his license. I think there's fines and costs and fees associated with getting that license back. He's working through that. I indicated to him that if he can show verification or proof of a valid license, I'd be willing to dismiss the case in its entirety. So I would ask for a new date to be set, Judge, so he can continue to work on getting his license, and then I can hopefully submit a nollie to the court.
Mr. Miller, you have fines and costs where? Do you owe? Where do you owe?
Oh,
fines?
no, not yet. I'm through the Secretary of State.
Oh, you owe Secretary of State money?
Yes. When the court dates, I gotta get put up, get set up, because you just can't go out there. I gotta go in front of the court.
That's why I'm asking, where do you owe, what courts do you owe money to?
No, not, I don't know. Oh, yeah, but it's coming. You know, as soon as
Oh,
I
okay, got it. How much time do you think you need?
get my 30 days.
30 days?
There's
Okay,
nothing's moving, excuse me, I'm sorry, nothing's moving fast with.
I know. That's why I asked you how much time. It's not gonna move fast. We can do 30 days from now and you come bring us an update.
Yes, I will.
Thank you, Your Honor.
Thank you.
December 10th at 10. December 10th at 10. You have any questions? We'll get you a notice to appear to remind you of the date. Any additional matters, counsel?
Nothing additional from the people, Your Honor. Thank you.
You're all set, Mr. Miller. And you all just want Holly reset, you said?
Yes. Scheduled for December
December 5th.
at 9 AM, I think.
You see Kaiser,
Was that your honor? Kaiser?
Zoom, Connect,
I do believe Ms. Sutter spoke with him. I think it's gonna be a dismissal before that.
dismiss, you can just let me know, I'll just write it on the file.
I just haven't received proof. yet,
Oh,
Your Honor,
okay,
so I
got
can't say for sure.
Okay, show cause for Clark. Let's see, Clark.
getting old.
Hate to wake you up. Which court are you looking for?
This is more the honorable Judge Warren.
Okay, tell them they logged you into the wrong courtroom. You're in Judge Simmons.
All right, thank you.
You're welcome. I don't, they still not have anybody in post 2 responsive, so. Someone in post 2? Indian King?
Yeah. Yes. Zonkamig Kaiser. Sorry.
Your Honor, the judge, judge says have Mr. Rowley come on in for it. Thank you. Yes.
Okay, Bullock was supposed to be an alley, is that what's going on?
Yes, Your Honor.
I do.
Sorry, let me help you pass these up.
Okay, I don't have one. Yeah.
Okay, he was my story.
On the record in the matter of the people of the state of Michigan versus Jordan Brown 24-02155. Council appearance.
Morning, Your Honor. Case Mark Hearing, appearing on behalf of the people.
Jacob Rowley on behalf of Mr. Brown.
This matter was scheduled for pretrial and a PA 53. How are we proceeding?
Your Honor, with regard to the underlying case, we would ask that it be set for final pretrial and trial dates. However, my client is prepared to plead guilty to the PA 53 violation.
That's how you want to proceed, sir? Raise your right hand. You solemnly swear or affirm a testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
Violation here. You were arraigned on, it looks like back on the 15th by Magistrate Millmore. You pled not guilty to the allegations that you violated the bond condition by picking up a new charge. Is that accurate? Yeah. What's the status of the new charge?
I don't believe he's been arraigned on any new cases yet.
Okay.
Okay. I did receive a police report that mentions the allegation of furnishing false information to police. And that was the new charge they had in mind.
You say you did receive a police report about the furnishing false information?
I did receive that.
Okay. As to that violation, you did have the right to have a contested hearing. You had the right to require the prosecution to put forth evidence that would establish the violations beyond a reasonable doubt. Do you want to give up your right to have that hearing?
No.
You want to have a hearing on the bond violation? Or do you want to plead guilty to the bond violation?
The bond violation, I'm plead guilty to that.
Okay, so you do want to give your right to the hearing on it. Anybody threatening you to do that? Who's threatening you?
No way.
The promise is being made to you to give up the hearing.
No.
Okay, as to the violations from on or about October 15th at 8:10 or 7:24, that is, in the morning. Furnishing false information to an officer, how do you plead?
For the furnishing false information.
Well, no, as to the violation that you
guilty.
violated your bond, how do you plead?
Guilty.
Factual basis?
Mr. Brown, is it true that you were placed on a bond by this court for a case involving Jeffrey Brown? Is it true that one of the conditions of that bond is that you're not to, you have the address of 2403 Turner Street? Is it true that on October 15th, you in fact were at that address and the police were called out and found you to be at that address? And you acknowledge that that is a violation of your bond conditions?
Any additional? Basis, counsel?
No, Your Honor, the people are satisfied with the factual basis.
If we're satisfied with the factual basis, I will accept your plea if I get plea made to you voluntarily and intelligently. Let's see, final pretrial. It'll be November 26th, I think. November 26th at 8 a.m. Trial January 13th. Jury trial will be January 13th at 8 a.m. Both of those are in person at the court. Do you have any questions about that, sir?
No.
Credit and time served on the violation. You need to appear in person for your next two court dates. Do you understand that? You failed to appear back in August for pretrial, so you were in warrant status when you were picked up on this bond violation. So you had two court dates and you rescheduled it for the same time.
Yeah, that was a misunderstanding on my part. I read the paperwork wrong and I rescheduled one and it turned out to be on the same day and like an hour before or after the other one. And I'm unable to make it the other one on time.
Okay.
And
Well, we'll make sure you don't forget your court dates and we'll see you in person on November 26th, okay?
Your Honor, if I may, for
Yes.
the record. I just wanted to bring to the court's attention the address that was listed on the pretrial release order as the defendant's address is also the home of Jeffrey Brown. I don't know what the living situation is, if he has somewhere else he can stay, but it would be a violation to be released to that address. Once again, that's how we got this violation. I'm not sure if Your Honor can order or would be able to, but I would have no objection if he was to be released to an inpatient treatment facility for sobriety and substance abuse treatment. However, I just wanted to bring to the court's attention the address on the pretrial release order is the reason why we got the bond violation and where he lived.
The 3428 Preston.
And maybe there was an updated address then, Your Honor. The pretrial release order I saw still showed the 2403 Turner address.
No, I have 3428 Preston and from the date of his arraignment, that's the address he provided before, actually. I don't know why they would have put another address.
Okay, never mind.
Let's see here. I can't really read. Okay, let's see here. He was arraigned back on August 4th. That was the Turner Street address was on that one.
Yeah,
He was arraigned by Buchanan on that date, however. That address, I think, is probably put there by maybe the jail staff, I'm not sure whose handwriting that is. He, at the time of his arraignment on that date was told but he couldn't stay there. He provided an address of 3428 Crescent as the address that he would stay in, and then he was advising he got to be within 2,000 feet of Jeffrey Brown's home worker school. So that's not, I don't care what the address is on that paperwork. It's clear, or should be unequivocally clear to you, that you're not to be at the address of the victim, because the address of the victim can change from today to tomorrow. You're still not to be there. You understand that? You have any questions about that? Okay. Any additional matters for today's work?
There you go.
Oh, yeah.
You're all set. Do we have anybody else in custody?
Yes, Mr.
He's downstairs?
He's here now. He was at Buchanan until David brought him over.
Oh, he's behind there.
Yes.
Who represents him? Feigelson. You see Feigelson's not here.
So it's gonna, I emailed him, it's gonna be. Because he has a preliminary exam scheduled this Friday.
So we reset day Jueves, is
Yes.
what you're saying? Oh, I need to arraign him on another bond violation, it looks like.
Okay.
The sentencing. Hmm? The sentencing. Day Jueves, page 53. Sentencing for what? Sentence for further probation number 15. Being sentenced on what? He's scheduled to be sentenced, but on what though? I don't know what he pled to. It says he failed to appear, turning his head, no contact. Let's see. He pled guilty to added count 3 of assault. Sentencing was February 21st. Then it failed to appear on February 1st. And attorney had no contact. I issued a bench warrant and remanded him. Then it says on the 18th, it looks like he was picked up. Sentencing referred to probation. Remand for bond violation hearing. Okay, so we must have seen someone in a bond violation. They just didn't put any notes here. Very blank. I'm assuming he pled not guilty. There's not in the doesn't say what he pled. Okay, I have a bond violation here that it's not clear to me as to whether or not he was arraigned on this.
I'm trying to figure out about myself, Your Honor. Mr. Feigleson had a lot of notes in the file, particularly on the 24th and 25th.
Of October?
That's correct, Your Honor.
Yeah, our last notice from October 18th.
He's got a lot of notes in the 24th. There from
There's some notes and some signatures I can't really identify. Remand for bond violation hearing, but no one addressed whether or not he was arraigned, and I don't even know whose handwriting this is.
Yeah, Mr. Feigleson has a note in here from 10/23 that says we're set for PCC for Friday 10/25 at 9:30 before Judge Simmons. So I don't know if there was something that happened
On this
last
file?
Friday.
Or another file?
This is 3193 FY, am I correct?
No, this is 533.
Oh, I apologize.
23-03533, which looks like he was supposed to be sentenced on back on February 1st, but he never appeared.
On 10/18, Mr. Raleigh has a note that says Mr. DeWelvis was arraigned today on warrants on old cases and one new file. And then there's just notes from Mr. Feigleson of setting up an appointment with Mr. DeWelvis in custody to discuss sentencing.
Okay.
10/24.
Doesn't say anything about a bond violation.
Not that I can see, just Mr. Raleigh's notes from 10/18 about arraignment on warrants from old cases and then some.
That's probably this one. It looks like the bond violation is that he allegedly picked up new crimes and he was not to use alcohol.
Admittedly, I do not see that within the time.
Okay. So just to be safe, I do have a bond violation here. under a complaint of violation of conditional release. The allegations are that on or about the 17th of October 2024, that you committed the violations of allegedly assaulting a friend with a knife and that you were intoxicated, and that this would be a violation of your bond conditions D and G, not to commit any crimes while out on releasing, not to use any alcohol. So you have the right to have a contested hearing on those violations and be represented by your attorney and have evidence brought forth that would establish beyond a reasonable doubt if there was a bond violation. The court will enter a plea of not guilty on your behalf for that violation. And I'm assuming that the new case was is that the assault with the knife?
I believe so, Your Honor, 24-03193, which I think might be set for hearing end of this week.
Yes, preliminary exam Friday at 9:30.
Put on the date I'm supposed to be here, so we can set it to. The sentencing for what day? For this, for the 17th, but I can set it out. Okay. January 6th. Well, for the 17th, you can probably do it too, because at this point. I don't think we need a PSI. Oh, you don't? Okay.
It's currently set for, I think, November 15th at 9 a.m.
November 15th? No, it was no, so she needed more time to do the PSI. Which was, it was set to December 17th. Oh, no, they set it for December 17th. No, we'll move it up. To the we can do this. Why can't we do this December 16th? It's, the 17th is when it was scheduled. You're that right, and I'm not gonna be here the 17th. Right. The week before that. December 10th at 9 a.m. for sentencing. And then for the PA 53, he has an exam this week.
Yes, Your Honor.
Friday at 9:30.
Let's set that for November 1st at 9:30. Any questions for the court today?
Yes, I was supposed to have a probable cause hearing on Friday. My attorney never came to court. They never called me to come to court Friday for the probable cause hearing.
So they can let you know prelim on Friday. Mr. Ferguson at the meeting are set for tomorrow. So let's be with you about that. That's not.
They never called you to come to court. You talked to your attorney before last Friday?
I did, yes, and all that he told me was about the new case, that if I plead guilty, not guilty.
Well, I don't want to hear what he talked to you about. I just want to know if you talked to him.
Oh, yes.
Because he likely conducted the probable cause conference and then notified the court that you were going to continue to your exam. Which is, well, that's what the point of the PCC is anyway. For him to talk to you, let you know what the offer is, and then decide if you want to run your exam or not, okay?
PCC can handle the emails with this gentleman. So that is tomorrow. We already got this.
Okay.
You'll see Mr.
But I sent him messages.
Any other matters or questions?
No, Your Honor, I can confirm for the record, Mr. Feigelson did handle the PCC via email off the record.
Makes sense. I know I was off, so it makes sense. Any additional matters for the record?
Nothing further from the view.
Nothing further.
You're all set. You ready on Kaiser?
Yes, Your Honor.
Yes, sir.
On the record in the matters of the people of the state of Michigan versus Meg Kaiser, 24-0284546 and 47.
Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing today on behalf of Mr. Kaiser, who is joining us via Zoom.
Okay, I have three filed here, unlicensed dog. How are we proceeding?
Your Honor, I have received proof sufficient for all three. I've received a license for 2 of the dogs in question that are now valid and in compliance with the statute. The third was put down not too long ago, so we have no reason to continue on that case. The people are moving to dismiss all 3 in the interest of justice.
No objection, Your Honor.
Motion to dismiss is granted. You're all set, Mr. Tyson.
Okay, thank you.
You're welcome.
If Mr. Schaefer's here on Zoom for the poll.
All right.
It's just gonna be a.
Great.
Okay,
You're all set to leave, Mr. Kaiser.
you're free to go, Mr. Kaiser. I think I signed the knowledge
Thank you.
already.
Have a good day. Bye-bye.
Maybe I didn't sign the knowledge. What was that?
Wanted to
Oh, I have it right there.
anyways, if we could, Your Honor, on that one.
On the record in the matter of the people of the state of Michigan versus Andrew Bolick, 24-02785. Appearance, please.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Stuart R. Schaefer, SHAFER, on behalf of Mr. Bolig, appearing by Zoom. My client is not present.
Why?
It might be, it's certainly my fault. It appeared that this was going to be a dismissal. I advised him he didn't have to be here. He still has mental health issues. He's being treated. I wanted to not disrupt his life as much as possible. So, but
I recognize that, but he has a bond violation and the prosecution can't dismiss a bond violation.
I understand that. This is my error, Your Honor. I apologize.
Okay, so this is being dismissed. Says restitution already paid. Defendant has vacated property. However, I had a bond violation out alleging that he violated the terms of the conditions of the bond, not to purchase or possess a firearm or dangerous weapon, and not to assault, harass, intimidate, beat, molest, or wound the alleged victim.
May I address that briefly?
Well, I think Mr. Markarian wanted to address
Yes,
something.
Your Honor, if I may. I spoke with the necessary witness and victim on this case, Victoria DeLista. She is a property manager for a community. To provide the court with some additional context, that's what this whole incident stems out of, is a destruction of a fire extinguisher box that totaled $136. Mr. Bolig, I think through his family, but Mr. Bolig has paid restitution in full. He's vacated the property. The keys have been turned in. A no trespass order was sent to LPD by Victoria Jalista. And after communicating with her, it was my understanding that she did not plan to show up to court or proceed on a bond violation because she felt it was unnecessary now that he's already gotten some sobriety and substance abuse treatment. And I can defer to Mr. Schaefer on exactly what the treatment is. But that was my main concern as well, with sobriety and substance abuse treatment. It's my understanding he is at an inpatient facility at this point.
Mr. Schaefer.
Thank you. This isn't a substance abuse issue. It's a mental health issue. After he violated the bond, a condition of he was incarcerated. A condition of his release was that he have a mental health evaluation. He had that. They found him to be a person in need of treatment. He was transferred to Stonecrest and treated for several weeks before they would, and he did it as voluntary admission while there, but they wanted an order for follow-up. So they filed a petition that went in front of Judge Dunning's. The petition was granted for additional inpatient. They only kept him a couple more days and they discharged him with a follow-up order. And he is compliant, but this is not a substance abuse, but a mental health issue. He's has a PhD. He's well functioning when his mental health is good, and we're hoping that we'll soon have him resume to be self-sufficient. His parents are caring for him and currently supporting him.
Okay, with that information, the court will dismiss the PA 53 Denali. This is being it doesn't indicate if this is being dismissed with or without prejudice.
I would just request to be done without prejudice, Your Honor, in case there are any lapses or issues with the mental health process.
Okay, the dismissal without prejudice has been signed. So that should resolve this matter. Thank you for the information, Mr. Schaefer.
Thank you very much, Your Honor, and I apologize for not having him here. That's my fault. I'm sorry.
No problem. Any additional matters for the record, counsel?
Nothing from the people.
No, Your Honor.
You're all set on that.
Thank you. Bye, everybody.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Bradley Cross, 20-01413, council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Jacob Rowley on behalf of Mr. Cross.
Okay, today was the date that was set for pretrial. Domestic violence, let's see. You're not offering this?
Yes, Your Honor. The offer was to plead guilty as charged with 76948 status.
This time, Your Honor, we request that this be set for final pretrial trial date.
Pretrial November 26th at 8. November 26th at 8 a.m. Jury trial January 13th. January 13th at 8 a.m. for jury trial. Both you must appear in person, okay, sir? Can you hear us in the jail?
Yes.
Okay, did you get your next court dates?
January 13th.
November 26th and January 13th.
Okay.
Both in person, both at 8 a.m.
Okay.
Any additional matters for the record?
May I address bond?
Yes.
My client is currently being held without bond. He has been in custody since October 11th. His 19 days is today. My request would simply be that he have to be released on PR.
He's not getting PR bond. He was supposed to be here on July 2nd. How many days was that before he was picked up? He never showed up to court to take care of his case. So I'll give him a bond, but it won't be personal recognizance. $500 cash surety.
Your Honor, I would just request if he is released and is able to post that bond, that he be released with a GPS tether and victim notification if possible, since it is a domestic violence case.
He didn't have an issue with violating the no contact before, did he?
I don't think so, Your Honor. It is a bit of an older case. Admittedly, it might not be necessary. I'd just like to request it out of an abundance of caution since it is a domestic violence case.
We typically don't just grant a GPS tether just because it's domestic violence. Typically, the bond is a PR bond on a domestic, and this was originally a 300 personal recognizance. There was no GPS tether ordered. The issue we had is that he failed to appear for court back on July 2nd, and several months went past, and he still didn't address his court date. I don't have anything in this record that would indicate that the bond is an issue, so I will not order GPS tether. Because I think that portion of the bond, I guess, is being complied with. I will, however, impose a cash surety bond because he can't remember to come to court.
Thank you, Your Honor.
Thank you.
Any additional matters for the record?
Nothing for the people.
Thank you. You're all set, sir. That's all we have for the morning.
Yeah.
Okay.